amongst other things, the definition of a plant, whether the evidence at issue was producing food from photosynthesis, and of course, usable marijuana with a splash of Manuel and Mansour mixed into the fray. When we showed up today, I'd say much to my surprise, the court was very familiar with, or gave the appearance to be familiar with, the conflict of law that currently exists in the medical marijuana world, and which were created specifically for the Mansour opinion, and this judge today was prepared to grant a stay in the proceedings potentially until the mess gets worked out. Court heard arguments about the parties, but the real issue at hand in this particular case, which is not so much what I just described about medical marijuana, but about the warrantless search of my client's home and whether the government could constitutionally validate the warrantless search. As is often the case in warrantless searches regarding drug task forces investigating marijuana tips, this case dealt with the old knock and talk. That's right, knock and talk. This is a real thing called a knock and talk. It's a thing in the law, and it is a tool used by investigators which allows them to traverse onto citizens' property to question and even investigate a person or a citizen. The knock and talk, however, is not absolute, and there are specific limitations. The best way I've used to describe this limited police authority, taking from some court appeals opinions, is that it would be akin to allowing someone onto your property in the same manner that a Girl Scout would enter and have access to the front door, or another person soliciting, or the mailman, or a person delivering a FedEx package. Knock and talks are generally legal, assuming that the police limit their interactions to the areas of the property that a citizen would not have an expectation of privacy beyond where a Girl Scout or those examples I've given would be expected to go. Examples of this limitation to walking up the driveway and onto the porch to knock on the door is essentially the limitation. There's nothing more than that. There's a lot of significant case law, especially in recent years, that lay out the particulars of what is a lawful knock and talk. One that comes to mind is this Frederick and Van Dorn that was out of the Kent County Circuit Court, went to the Michigan Supreme Court, where the sheriffs got a knock and talk like 4 a.m, and the analysis of the case was it's based on a totality of the circumstances. I think ultimately they found that the knock and talk was invalid, illegal, which made the search illegal, and what came after that.
They said the Girl Scouts couldn't knock on your door at 4:30 a.m.
That would be the analysis.
Yeah, that would violate curfew, right?
And that's what the Michigan Supreme Court said and described those limitations in that particular case. And despite the fact that the court did not take issue with the police detective investigators in this particular case, the court did not take issue that these particular investigators were not in police uniform when they did their knock and talk. And the whole premise of the knock and talk, I would argue, is that if you come to your front door when you hear a knock and you see a Girl Scout, you can decide whether or not you can open the door for the Girl Scout or not. You may go to the front window and point to the sign that you have on your door which says, "No soliciting." You may have someone come to your door that you don't want to answer, and you have the choice of opening it or not opening it because you can identify who they are. You're not.
Is that your legal advice if you're prompted with a knock and talk, point at the sign and say no soliciting?
No, I'm saying to the Girl Scout, to the salesman, to the Fuller Brush man, salesperson.
The Jehovah's Witness.
No soliciting. What I'm talking about, though, is that in this particular knock and talk, the individuals were not in police uniform. The knock and talk method allows police officers to go onto the porch because they are police officers, not undercover people hiding their identity, because then when you come to the door to open it, it is not known who you are opening the door to. It's not a Girl Scout. It doesn't appear to be the police. Maybe you have a rule, I don't open a door for the police ever, and they aren't identifying themselves as such. Now do you understand my point, Jim Powers?
I mean, I understand the point. I'm just wondering.
I'm not to the legal advice yet. Stop.
Okay.
I'm saying that they showed up not as police officers and claimed that it was a knock and talk. In other words, if a neighbor shows up and you think it's a neighbor or somebody else that's not a police officer, you may be inclined to open the door. If they're hiding their identity as a police officer and claiming they're investigating something as police officers, there's an inherent misrepresentation. The court, as I'm making the same argument in vain, felt the same way you did. So I'll move on.
The same way I did, huh?
Even though I disagree with the court on this particular issue, this wasn't the ultimate issue that was dispositive in the case. The legal issue that was dispositive of the case was that once the police officers who were conducting a lawful knock and talk and who were lawfully on the porch of my client's house and were lawfully ringing the doorbell to interact with my client with the intent of trying to establish probable cause to search and possibly get a search warrant at some other time, it is around this circumstance and what happened thereafter that was a dispositive issue. And this is happening more and more in cases, and that's why I think it's important that people have a full understanding of what is taking place and how to deal with it. So here comes the legal advice, Jim Powers.
Lay it on me.
Don't give me a time limit either. As we've been finding more and more, there seems to be an additional tool by investigators to denigrate the immunities from arrest, prosecution, and penalty, or what we like to say is Section 4, by suggesting or requesting in these circumstances that they be allowed to do or that they need to do a compliance check of the homeowner's medical marijuana compliance. Let me say that again.
Just spot check.
They are at your door and there's a claim that there is a tip and they're there to investigate.
Listen carefully, Dave.
And you're having this encounter that you know that they do not have a search warrant, number one. They're there for a tip about marijuana. So, what happened here is that, as I mentioned, this case involved a search and seizure of evidence where there was no search warrant. The U.S. Constitution, the Michigan Constitution, expressly prohibits the searching and seizure without a warrant. That, in fact, warrantless searches and seizures are per se invalid, and it is illegal, and governments are not allowed or authorized to do so. But if there is a search without a warrant, it then becomes the government's burden to prove why there was a warrantless search, and there's certain exceptions that they can offer and proffer to maintain why a warrantless search would be valid. And in this particular case, the government's theory of why the search and seizure of the evidence in this was constitutionally valid was because, according to them, my client consented. Listen to me now. Consented to the search of his house. The government in this matter argued my client consented to a search of his house and offering testimony of the officers who said my client consented to the search, and therefore the government didn't need a search warrant. And you know what? This theory is true. In a warrantless search of a house is per se illegal unless there is consent. Only the homeowner's consent justifies the warrantless search. I argued, of course, that there was a conflict in the testimony being suggested by the prosecutor, because in this particular case, the preliminary exam, I had an opportunity to cross-examine the officers that were engaged in this particular investigation. And what they said was that when they approached my client's house and they asked if they could come in to search for illegal contraband or whatever, arguably they would have made them performing a constitutionally valid search and seizure, when we got to that issue and those questions were being asked, they admitted things that the prosecutor wasn't really being forthright with. The state's position was that they relied on the investigators who said, we got consent. But the real testimony was that when they arrived at the location, and as it would make sense and logically plays out, officers are there, they're investigating a marijuana tip, and they knock on the door. You don't know it's a police officer, you should. You open the door, you come outside to talk to them, as the facts developed here. They say to you, they say, what can I help you with? They say, we're police officers here, we're investigating an illegal marijuana grow. And you say, well, officers, you have nothing to worry about. I'm a medical marijuana patient. And you have nothing to worry about. There's nothing illegal going on here at all. And any concerns that you may have had of smell or whatever, I'm a patient. Here's my card. In other words, at that moment, the investigation, whatever the knock and talk and their attempt to go probable cause, one would be vitiated. There's no even, like whatever their tip was, now it has been reduced or not corroborated. And further, if they smelled marijuana, it's explained now because of the patient status. And the presentation of the card is an exercise of an individual's proclamation to be immune from any even suggestions of criminal behavior. So, really the first line of argument here is that if they're arguing consent and someone gives the card, that's like, no, there's no consent, there's no legal activity. But after the card is given, the police officers didn't give up there. They said, well, we need to come in and do a compliance check to make sure that you are in compliance with the Michigan Medical Marijuana Act. Now, this is where it gets fun for me, because I know, and most people know, that the MMA actually precludes and prohibits the searching of a house by government officials for compliance checks. There is no legal authority for the suggestion that the officer come in or need to do a compliance check.
There might not be any legal authority, but maybe they didn't in this case, but they typically threaten you.
And what if they
say,
smell
you're
marijuana?
either letting us in or we're coming back with a warrant and we're going to rip up your shit.
And what does that do to the voluntary nature of the consent to search?
Right.
And that's the point here. Here's the point. Jim, what you're saying is true, and I can come back to that and return to that answer. But this case unfolds as follows. The officer says to my client on the steps outside of his house, after the card's been presented or resisted for entry, well, we need to come in and do a compliance check. Suggesting, or can we come in and do a compliance check, even if it's asking. Suggesting, implying in either question that they have some legal authority to do that. Now, in the cross-examination, I say to them, are you part of the MMFLA's task force? They said, I don't think so. And I can see in their eyes, like, that sounds like something I want to be part of, because that sounds like I can then get into places without a warrant. Right? Yeah. So I'm like, so explain to me then what the legal authority is by which you're telling this person that you can come and do a compliance check. And he says, I'm a trained officer for 21 years, and Michigan State Police, I went to blah, blah, blah. I'm like, okay, I'll tell you what. Let me ask you this question. Tell me about the history of your background as a police officer. Did you just do that? Okay. Now, I asked you the question that you wanted to give the answer to. Can you answer my question now? Point me to, find me a statute, a place in the Constitution, a place in the statute that gives you the authority to do a compliance check.
Objection, asked and answered. That's what the prosecutor says. He doesn't want you to get to your question.
Of course. But at the end of the day, there is no legal authority. And they may, whether the question comes out or not, he can, yes, asked and answered. That's the answer to the question. What's your legal authority for my training experience? Okay. Well, you're wrong. You've been trained. And when I argued with the judge afterwards, if that's your answer, Judge, the law says this. And as a matter of law, there's no legal authority. So, in order to tell somebody or suggest to somebody when the ultimate issue, Jim Powers, is consent.
Right.
As we sat there and argued back and forth about different things, I said, look, Judge, let me break it down here real easy. A warrantless search is per se illegal. The state says they got consent. Let's look at how that happened. In order for consent to be valid, it has to be knowing and voluntary, without duress, without persuasion, without unnamed promises, and without any equivocation. The classic circumstances, if they ask you a question like, then I guess you don't mind if I search your vehicle, and the guy raises his shoulder and goes, I don't know. Like that is not unequivocal